Hello, everyone. My name is Larian Rodriguez, and welcome to our Up and Out seminar. I am the program coordinator for the transition program here at the Veteran Spouse Network. Here at the VSN, we feel that transitioning out of the military is a family affair. It is not just the service member that is impacted. It is in the entire family's best interest that everyone is involved. And there are a lot of elements to transition. So our Up and Out seminars, we try to cover relevant topics that are pertinent to our entire military family. And today we have Keri Mills as our guest, and she will be talking about the importance of estate planning. So here's a little bit about Keri. Keri is the widow of a special operations chief, Matt Mills, the Navy SEAL who died in Afghanistan. Keri is originally from California, and she has a 10-year-old son, Cash, and they now reside in Houston. Following the death of her husband, Keri realized that her personal experiences that was desperate need that within the special operations community for estate planning services and to be readily available to our military families. She's involved in the Gold Star Families program, and she received multiple degrees and awards from all over. And she is also elected to serve as the president of the Student Bar Association and works for a lawyer currently here in Houston, Texas. So Keri, would you like to follow up with anything on your intro, or why don't we just go ahead and get started?
Yeah, no, you did an excellent job. Thank you so much for having me. I'm excited to be a part of this this Veteran Spouse Network. You guys seem to provide an excellent service for transitioning veterans, and I think it's so imperative that we not only get the information to our veterans, but that are serving, but we don't forget about them as they transition out into the civilian world. So I'm honored to be here. Thank you for having me. You did an excellent job of kind of giving a snapshot of what brought me here. It's been an 11-year journey. I lost my husband. It'll be 11 years in August. And I started this journey not having a college degree. I had a high school education. And so moving forward on this through this has been not only a journey, an educational journey, but I've learned so much about myself and about our community and how to give back. So again, thank you for having me.
Thank you.
Yeah. So I have a lot of information. I'm going to start out with kind of a 10,000 foot view on and a snapshot of kind of estate planning in itself. So there's a whole lot more that goes into it than just a will. And so I'm going to kind of walk through the process of how to get to that point. And I want to give the group and any individual who sees this recording or is with us today. I see we have someone that jumped in. It's lovely to see you. Kind of the questions and the information that they need to take with them when they go and sit with an estate planning attorney. And I know that many people have the ability to go visit the JAG office, or you can go outside. But a lot of times we don't know what to ask because this profession, the legal world, is incredibly antiquated, and the language can be a little bit overwhelming. So that's kind of where we are. So I just kind of want to start with why I feel that it's so important to plan for your estate. It's really a couple of things. Number one, it allows you to have really hard conversations with your significant other or someone who would manage your estate if you are not married. It allows for you to tell them how you would want your estate to, how to be managed, where you want your things to go, whether it be real property or personal property. And you allow yourself to take that weight off of the individual who's managing your estate when you're no longer here, and not only no longer here, but in a state of incapacity. So that's a big portion of the documents that we draft in the law firm that I work at, and what I would recommend for not just a service member, but anybody that came through, our doors and asked for some guidance. And so, really there are three types of families. There's, or a family member dynamic. So you have a single individual who's not married. They may have children, but they're still single, or you have a married couple. And then you have what we see a lot of times in our military community are blended families, especially the longer that you serve. A lot of people come right out of high school. You have your high school sweetheart, you go into the military, God forbid something happens and you get divorced, but you remarry and you might have children from a previous marriage and you might have children going forward. And so this is where estate planning becomes really essential. I'll give you a perfect example of that. So when my husband was killed in action, he was my first marriage, but I was his second marriage. He had children from a previous marriage and we had a child together. So we are the absolute perfect example of a blended family. And so when he planned for his estate, he didn't get the great information about how to take care of his kids from a previous marriage and how to take care of us. He did have it done on site with a JAG officer. Not that they're not well equipped, they are. I just don't think that he knew the right questions to ask, and that's what we're going to get to today. And so when my husband passed, his wishes that were written out in his will did not translate to some of the other documentation that pass outside of the will. And we'll talk about that a little bit later too. So knowing the language, knowing the questions to ask, and how to provide the information to an attorney or a life insurance policy expert is really important, especially when you get into a blended family. So what we look at in a service member, or we call them a primary next of kin. So that when someone passes is the person who would manage your estate, that would manage your effects, that would manage how your financial things would happen. And that was how things were passed. So usually it's as a service member, the primary next of kin would be their spouse if you're married. If you're not married and your parents are still alive, it would go up to your parents. And then there's a whole list that the state manages on who would do so. But as a service member, usually it's your spouse. There are three types of property. You have your personal property, you have real estate, and then you have community property. And in the state of Texas, it's one of 9 states that's actually a community property state. California is another one. So there are only 9. Most states do not have community property. And what a community property exists of is something other than separate property. So it's acquired by either spouse during the marriage using marital funds. So if you guys go out and buy couches together, you use your, you buy couches, you use commingled funds that you've earned from your job, and you go ahead and purchase this couch. That would be community property. Same if you purchase a home together. Even if you don't purchase a home together and say one spouse purchases the home on their own, if the mortgage is paid monthly with commingled funds, then it's considered community property. And then you have separate property. So separate property would be something that was owned entirely by a spouse prior to marriage. It would be property that's acquired by a spouse during the marriage by a gift, or if it was devised to them in a will from a family member or someone else who's given them through their will, or it's descended upon them from a family member that did not have a will. That would be a descent wise. The process of these different properties is where we get a little bit confused, because personal property and community property are going to be managed within the state that you reside. But when you have real property and you own it in a different state, which a lot of times we own property in different states because we get billets in different areas, or we move throughout our time while in the service, real property upon death is going to be managed by the state in which it resides. So that will pass unless you share, you own it, and it will pass the way that the state that it's in requires it to be passed. However, that can all be documented, and if you own the home together, it will pass to your spouse unless otherwise stated. I will tell you that along with community property, Texas is a state that recognizes the common law marriage. So it's the easiest state out of all 50 states to prove that you're married. So you only have to do 3 things. You have to hold out as that you're married, you commingle funds such as bank accounts, or you cohabitate together and you share all of the information, publicizing it, meaning you say it to another person. You don't see very many issues where people are trying to prove that they're married, but there are some instances where if there was not a will in place, that someone might want to prove that, because as a spouse, you receive the benefits of being married, which would mean that you would receive the property of your spouse solely. So those are some things that you really want to think about when you're holding yourself out. If you want to be held out as being married, then go right ahead. Now, having a will, I think everyone should have a will. And the reason why I say this is because even though maybe we don't have a lot, maybe we do have a lot, having a will allows your property to pass how you want it to pass. And you get to determine how that property will pass, whether it be to your spouse, whether it be to your children. You can allocate it percentage wise, and you can allocate it, or you can allocate it at age, or you can create a trust that will set up a safety net for your family members and their receipt of your personal property, your tangible property, your personal property, any of those items that you have. Let's see. There's a lot. I told you there's like 10,000 foot view, and we're working our way down. So if you don't have a will, let's start there. If you don't have a will, the state that you reside decides how your property will pass. Now, in the state of Texas, every single state has a law that will distribute your effects. And in the state of Texas, if you're married without children from a previous marriage, or if you have children together, everything goes to the spouse. It's basically their way of saying, this is what we think that most people would want. However, if you want something different than that, then you have to put it down on paper. And this is one of the things that I think that we miss in our military community, is the importance of writing things down, because life changes. And in our community, life changes a lot. And so I don't recommend that you change your will if you do have one regularly. However, you want to revisit it about every 5 years, because life does happen. And whether you have another child, or whether you get divorced, or maybe your financial situation has changed either one way or the other, that you'd like to reallocate how things pass at your death. It's something that I would recommend, like I said, visiting about every 5 years. So with that said, there are about 5 or 6 documents that we would recommend. Like I said, at our law firm, we recommend for individuals and married couples. We have your last will and testament. You have a statutory durable power of attorney. You have a medical power of attorney. You have a directives to physicians, which a lot of times is called a living will. And for individuals with minors, you have a designating of healthcare agent for your children, and then you have a declaration of appointment of guardianship for children. So I'm going to break down each one of those documents so you can understand the necessity and where they fit and how they play. So your last will and testament obviously does not come into effect until you pass, right? So you have the ability in your will to write down your wishes, like I said, to allocate your property, whether that be like personal property, or it could be bonds or stocks, or a portion of a business that you own. You can explain within this document exactly where you want it to go and who receives it. And so within that will, and I'm going to caveat to this and say that this is an entirely different conversation. A lot of people ask, should I have a will or should I have a trust? And it all depends. It all depends on your circumstances. And so if we're looking at a will, and say, like myself, take myself, for instance, I have a last will and testament. I have a will. I do not have a trust. However, upon my death, a trust is created that will benefit my son because he's a minor. So obviously he couldn't manage finances. He couldn't manage money at the age of 12. He can't manage any of these things. So I have, upon my death, a will that says, yes, I allocate this particular amount to my son, and I want it to go in trust, and I want this person to manage that trust for my son. And so I have a will, and upon my death, I will have a trust. And these are questions that you would want to ask the attorney, and you'd want to state, well, you know what? I'm married. If I die, everything goes to my husband. Should we both, die at the same time, and we have 2 minor children? I want to make sure that they're taken care of for the rest of their lives. And this is how you can do that. That's a way that you can do that. And there's also a way to where within that trust that's created, you can allocate distributions to your children at particular ages. Now, I give my son, 25% at the age of 25. I give him another 25 at, the age of 30, another 25 at the age of 35, and then he gets all the rest at 40. And you can be that particular and precise about how you want the trust to be distributed. So just that, like I said, that's a little small caveat, but I like to give that information because it's really important to understand that you really have control. You really have control, and you can control how your children or whomever you'd want to take care of after you pass. You really have the ability to control that, and all you have to do is write it down. So that's how I have mine set up, and I know a lot of parents that do that as well. They also do either at an age or they do percentage wise. So the next one is a statutory durable power of attorney. Now, a lot of our service members have power of attorneys that are created because our spouses or friends. I have had power of attorney for friends over the years because they weren't married. It gives individuals the ability to manage finances. So it could be the sale of a house, it could be filing taxes for someone, it could be writing a check out of their account to take care of all of their bills. However, I do want everybody to know that you don't have to give everybody all of the access to your finances. You don't have to give them. You can allocate in the powers that your statutory durable power of attorney allows. So if you say were overseas or you were on a vacation and you gave someone a POA because you're selling a house and all you needed them to do was go and sign in your name, you can absolutely have it just for that particular purpose. You do not have to give them access to everything that you own. It's kind of a scary thought, giving somebody access to write checks for you, to go into a bank and they could withdraw everything from your bank account. I mean, and I have seen some real horror stories of people coming back from deployment and they have no money in their bank account. They have nothing in their home. It's completely barren because they gave someone all of the powers of the power of attorney. So another part of the statutory durable power of attorney that I think that people don't realize is that that dies with the individual. So if you do not allocate access to particular bank accounts, or you don't add them to some accounts, then they will not have the ability upon death to go in and access that money. So this was, again, a realization that I learned really the hard way. So when Matt passed, we did not share finances. I had my bank account. He has his bank account. Of course, I had a power of attorney. I wrote checks. I did everything that I needed to do. However, I did not know that we did not know that when he died, the power of attorney died with him. So I could not go in and I could not take out money from his bank account to pay bills. He was the breadwinner in the family. I had, a regular job that, covered our grocery bills and a car payment. And so when I went into the bank and told them, that he had passed away, I had his DD 1300, they said, Miss Mills, we are going to freeze this account until you go through the probate process and you probate the will. So therefore, all of those funds that were in that bank account, I could not touch until the entire process had gone through the court system. And they said, yes, you are the rightful beneficiary and you now have access to this. And I'll tell you what, in the attorney's office that I work currently, the average probate process, a simple probate of a will, is roughly between 6 months and 8 months. We are so behind because of COVID that that it's just made it very, very difficult to expedite something along these lines. So ways that, and this is a conversation you have with either the recipient or someone who's managing your finances, a way that you can kind of bypass this is either you have a joint account and that's between the both of you, or you have something that's it's called POD or TOD. So you either transfer the account upon death or you make it payable upon death, and then you put the individual's name. So if I was Keri Mills and I had my checking account TOD, it would transfer on death to whomever. Say I put my mom's name in there or my fiance's name in there or something along those lines. This way, when you go to the bank, you are in this particular situation. You're not missing out on the accounts. I mean, the horror of it is that's where, like, for me, that's where our mortgage came out of. That's where all of the, a bill pay, everything came out of. That was automatic, and they literally freeze the account. So nothing happens. So just be aware of that. And like I said, something to chat with your significant other or whoever you give your statutory power of attorney rights to. You can talk about how to work that out. So the next one is our medical power of attorney. And this medical power of attorney is giving an individual the authority to choose in particular situations how to move forward if you were incapacitated. So this only comes to fruition if you're incapacitated. So you get in a car accident, you're in a coma. This allows for an individual to choose what happens with you and make the decisions on, one doctor says, we're going to do brain surgery. The other one says, no, we shouldn't do that. It gives you the ability to choose. And like like I've said in everything, these conversations you have, that way the individual who you're giving the powers to knows what your wishes are. And this is, I said, it comes into fruition at the point of incapacity, and the person that determines incapacity would be a physician. Obviously, if you're in a coma and you can't open your eyes and you can't speak, you're incapacitated. However, it could be a mental issue as well. So if someone is so far gone with Alzheimer's and they don't have the ability to make a cognitive thought, they could potentially by a physician be deemed incapacitated, so they couldn't make their own decisions on their own. And so that's when this medical power of attorney would jump into fruition, as well as the statutory durable power of attorney for your finances, that would spring into effect as well. And now we get into the documents, the two documents that we recommend for individuals who have minor children. So we have the designation of healthcare for agent for children, and then we have the declaration of appointment for guardianship. So the declaration of healthcare, this one is kind of your blanket. If you have someone who regularly babysits your kids, you have a daycare place that you take your children to regularly, your parents, either on either side, your spouse's parents, you can make this kind of a laundry list of individuals that have the ability to make decisions quickly if you're unavailable for the best interests of your children. A perfect example, I have all the examples that actually happened to me. In May, my son was with a friend of his, and they were out being kids, and he got pulled backwards and literally broke his knee in half. He snapped his kneecap in half, and he was with another parent with his best friend, and the dad called me and he's like, Keri, what do you want me to do? If I was unavailable, he would have to make those choices for the best interest of my child. You know, they wanted to put him in an ambulance, and then they wanted to take him to an ER. And I'm like, can't you just put him in the backseat of your truck? And they're like, no, we think his knee's broken. So these are things that allow individuals, like I said, maybe you're in a movie and you've got your phone on silent and you don't know that someone's calling. Maybe you're on an airplane and something tragic happens to your children. This gives these individuals the ability to make these decisions on behalf of your children. And then when we get to the declaration of appointment of guardianship for children, now, I would love to say that we get to decide if tragedy occurs and both parents are gone, that we get to decide who our children grow up with. In the state of Texas, and every jurisdiction really, the basis is the best interest of the child. So the state is going to have to approve the guardianship. And so what this means, this declaration of appointment, is really a very strong advisement, a very strong push from the parents to say, I think, growing up with these individuals would be in the best interest of my child, whether it be parents or family friends, maybe an aunt. One of the things that we tell our clients that come in, this also depends on the age of your child and the age of the individual who would be caring for your child. If you say it's your grandmother and you decide this and your children are 7 and 8 and your grandmother is, maybe in her mid 60s, that might work. But if you don't update this information and say you have a 16-year-old and then your grandparents are in their, mid to late 70s, is that really the best decision for your child? the attorney that I work for tells clients regularly that if this were to happen and your child is in high school and they've got a year and a half left, it might be in their best interest to stay within their community. And if you've got maybe he plays baseball and you guys spend time with the baseball family, and it might be in the best interest of your child to stay there, because then you have that normalcy, that regular life, normalcy, that they're going to have this huge void because their parents are gone. One of the things that go farther with that is that this is usually a very difficult topic for husband and wife, because the wife might have an idea of who's the best for raising their child, and the husband might have another idea of who's best in raising their child. And a lot of times it comes down to family members. And so I encourage you to have this conversation and be really candid about it, because sometimes family members aren't the best people to have raise your children. And so just take that into consideration when you guys talk about this. So with that said, I know it's a ton of information and I'm sure we're going to have some questions, but really from here going forward, what I want to do is I want to give you an idea of what you should take with you, and kind of the questions you should have when you go and speak to an attorney regarding your estate planning. First of all, take into consideration the cost. The average married couple cost for husband and wife, and that should include all of those documents that I spoke to you about today. It's not just a will. So it should include all of them, is between $1,500 and $2,000. So it's a hefty little paycheck. Sorry about that. There's a dog in the house. It's a hefty, fee, but it's worth it. If you have the ability to go on base and you still have services available at the JAG, they can draft up all of the documents that I've mentioned to you today. They have the ability to do so. However, I encourage you, the next list that I'm going to go down, to bring this information and ask them the questions that I've been telling you guys about, because a lot of times they don't prompt it. A lot of times you just will go in there, you'll fill out some paperwork, they'll put it into kind of a cookie cutter will, and then they kind of spit out something that's not really all of that tailored to what you want. My first will that I drafted after Matt passed was just that, a cookie cutter will. It was information in, input out. And then once I had started my educational process on estate planning, I realized some of these things that we're just not taught. We're just not taught in our community. And so the second will that I had drafted by the JAG, I had an attorney look over afterwards and he's like, this is much better. So just with the little bit of knowledge that I have, and a lot of the stuff that I'm giving you today will help you in the long run. Like I said, before you go, sit down with your spouse or the individual that would be managing your estate in the event of a tragic event or incapacity. Don't forget that incapacity piece. That's really important as well. And then have that conversation about the guardianship of your children. That also comes into place for incapacity, both of you being incapacitated. So it's not just death. So, think about a temporary thing as well. Have a list of all of the real property that you own, whether it's in Texas, Louisiana, Maine, Oregon, anywhere you own property, have all of that information. And if you have them listed as a rental property or you rent property out, make sure that you let them know that you are using this as a rental property, because there are ways to protect yourself as an individual. Say a renter is harmed on your property, make sure that you tell them that it's a rental property. That way If they need to put it into an LLC, this is an entirely different topic, like the trust topic, but they can create an LLC that is your rental property. So if someone was injured on that property, they can't come after you as an individual. So that's really good thing to have. List all of your bank accounts, know all of that joint, and know if they're jointly owned or separately owned. And if you wish to keep them that way, that's absolutely fine, but don't forget your, payable of death or transfer on death, for the reasons of the frozen accounts. Remember that your POA dies with you individually, and then, talk about who you'd want to manage your finances. And the way that we write our statutory durable power of attorney is we have them, kind of three alternatives. So you have usually it's your spouse, and then it would go to, alternative number 2, alternative number 3. So kind of have a list of individuals that would be able to manage that if you were incapacitated, in that sense. Let's see, what else do I have here? If you choose to go with adding a trust into your will, determine who would be the trustee, or because that doesn't have to be the person who has guardianship of your children. It can be someone else. And the trustee can be a person who's named as a beneficiary of the trust that's created within the will. And they'll be charged, the trustee is charged with administering or distributing the assets of property in the benefit of the decedent's named beneficiaries. And then executor, if you didn't have a trust, is the person who will execute the plan that's laid out in your will. So a lot of times they like to interchange them, but they're really two different roles. And again, an executor may also be a a beneficiary for a will. So like I said, there's a ton of space that I just filled in, a lot of information that I gave you. The last and final thing I want to touch on before we get into any questions is supplemental life insurance policies. So there are a handful of them out there that are available to our service members, and a lot of people know about the oh my gosh, it totally just left my brain. It'll come back to me. But Navy Federal offers some. There's a handful of them. Just know that is considered a legal binding document between the deceased individual and the life insurance policy company. So what that means is I, Keri Mills, have a life insurance policy. I have designated these individuals to be beneficiaries upon my death. Upon my death, that policy gets paid out, and it will be paid out to the beneficiaries. If I do not have the language in that policy that states, I want these funds for, say it's my children, to go into trust, it will be distributed out to your children. Now, what that means is, exactly in my case, my late husband had 2 children from a previous marriage. At his death, one was an adult, he was 18 years old, and the other was a minor, she was 14 years old. So with that said, that life insurance policy paid out, and an 18-year-old got a substantial allotment of money, even though Matt's will said, upon my death, I allocate my father to be trustee over the accounts, or for the benefit of my children, and it should go into trust until the age of 21. Because that language did not go into the life insurance policy, it did not happen that way. And so when we have situations like this, and an 18-year-old gets a substantial amount of money, I assure you, they spend it. And then it's not there for their benefit like you would want to see fit. And then for the minor, because she is a minor, her mother was able to manage that money for her. And it also did not go into trust, and it did not get managed in the way that Matt would have liked to see fit. And so just be really aware of those life insurance policies. And when you write out the beneficiaries, make sure that that language from your will and the allocation of it transfers over. It's a really real thing when you realize that, oh my gosh, this entire clause in here is in my will is null and void. And so that was the catalyst of me deciding that I needed to learn as much as I could about this and share it with our community, because we just don't know this kind of stuff. And so that's put me where I am today. And like I said, there is so much more, and there's a ton of information that can be given to you if you have any questions. There might be questions out there. Feel free to jump in and ask me now.
Well, Keri, thank you so much, first off, for not only sharing your story and your very brave personal example of what you've gone through, but also just the very realistic financial work. I took a ton of notes, and I'm gonna have to sounds like my husband and I were gonna have to get busy and talk some of this stuff out. I did have one question. Could you kind of explain the probate process a little bit? I've gone through it with my own family just a little bit on the outside.
Sure. So the two major would be obviously an individual who has a will, right? You die with a will, you go through the probate process. So you file with the court, you ask for application of an independent executor of the estate. Many times that is, well, if you have a will, it is a person who usually is named within the will that they are executor. And basically this process is there to show any creditors, any banks, anybody of the estate that would have kind of a piece of the estate in there, to show that you are the executor, you have the ability to make payments, or you have the right to the funds on the behalf of the estate of the individual. If you die without a will, and you have to go through the same process. However, you have to prove that you are an heir, and that the court will then determine that you're a dependent administrator of the estate. So really, well, not really. In the state of Texas, you have to probate a will. So basically, it puts on record that there has been a death. And then, like I said, you go through the process, and it can be, we're working on some that are still the better part of 2 years going through the process. It's a lot. So there are ways to kind of get around the probate process. However, most likely you will have to go through it. So the process is, you file with the court for the application, you go to a hearing, you basically state, yes, this is a will of the individual who's passed. Yes, I am the person that stated in the will that I am the executor. Yes, go through this whole oath process, and then the judge will accept the will into probate, and then they will give you letters testamentary. And letters testamentary give you the ability to go out to financial institutions and say, here I am, the court has deemed me the executor of the estate. You then will have access and the ability to bank accounts and, property and real estate, things like that. So to get there is a bit of a process.
Okay. Isn't there levels of probate based upon the size of the estate, or is that state specific?
Sure. There is a small estate affidavit, and it's under a smaller amount. I have to look up the amount. It's not a lot, but you can just file a small estate affidavit, and then you'll be done. The process is basically closed and done. And it's less, but the probate process can be fairly expensive. And there are many people out there who are trying to bypass the probate process by setting up trusts, and that would be one big way of being able to bypass the probate process, is setting up a trust. And like I said, that's an entirely different conversation, but that would keep you entirely out of the court system. Yeah.
Okay.
Yeah. And that usually, you see that a lot with larger estates. The trust, instead of setting up a testamentary trust within the will, setting up a revocable living trust while you're living, and then you transfer all of your assets and you title them in the trust name. That would be funding the trust at that point in time.
No, thank you. That was very relevant, good information.
Sure.
Does anybody else have any questions? Richard, you got to unmute.
Oh, hey, Lorian, can you hear
Hi
me
there.
now?
Welcome.
Hi.
Yes, hi.
Okay, Keri, Richard Smith, I'm Janie's husband. Okay, she keeps you on the straight and narrow. Great presentation.
Thank you.
Just for your information, veteran service officer for Coryell County, and I helped veterans and their widows file claims.
Oh.
And since COVID hit, I filed over 80 death claims for the widows.
Wow.
So, number one, there's a lot of ladies out there that have no idea at all what money they have entitled to, what
right.
bank accounts exist, or whatever else like this. So you did a great job on detailing, get a list of the bank accounts and stuff like this, get a list of the insurance policies, but also make sure, in the case of prior marriages or whatever else like this, make sure that the spouse goes in and alters the payee of the insurance policies.
Right. You need to update your years.
Yeah.
All of that.
Yeah. I just had a lady, her husband, she married him. He'd had a previous marriage, and they got divorced, and he was single for about 5 years, and then they got remarried. And after they got remarried, he filed for his VA disability benefits, Social Security disability benefits. All this money, it was awarded and went into a bank account, but he never put her on the bank account. And the payee was his nephew. So when he passed away, the nephew got the money.
That's right. That's right. That goes right
yeah.
back to that TOD, POD, or if you want to have a joint account, we call the signature card. A lot of times if you want to bank a signature card, if I see Nicole, she's like taking all these notes. I love it. If you go in and say signature card to your bank, they will 100% know what you're talking about.
Yeah. Great presentation.
Thanks.
I just wanted to throw that out there, or whatever else like this. And you said you're from California. I'm from the Bakersfield area.
Oh, very cool. I know Bakersfield well.
Yeah.
Very cool.
Have a good day. I'll let Janie get back in here.
Well, thank you. And thank you for your service, sir.
It was a hoot. It really was.
And Richard, I did want to say that I did drop into the chat the document you provided which is some really good resources. It is a little Texas centric, but it can be opened up and used nationwide. I'm not sure where all of our guests are from, but I hope that's some good relevant information for you. And thank you, sir, for hopping on there.
Right.
Back. But
here's Janie, the good looking one.
Nicole, Laura, do you guys have any questions?
When you said probate can be expensive,
Yes.
I'm kind of one of the planner. What does that look like? What's expensive?
Well, I'm going to say it depends, and that's I'm not an attorney and I cannot advise you.
Yeah,
However, every
yeah.
attorney would
But I
say it
mean, like,
depends.
are we talking like thousands or
Oh, yeah,
10,000?
we're talking, so there, a retainer fee, which means you pay up front, you don't get that money back. We're looking at $3,500, and then you have billable hours that are on top of that, that come from the attorney, and then his, paralegal or law clerk or whoever works for that. So, depending on the estate and depending on the assets that are available, better part $5,000 and upwards. I mean, some of these estates that we're working on for 2 years, it's substantial. It's really substantial. We have one that is there are a lot of children and beneficiaries involved, and there was no will. So we had to go find, a lot of them are in Mexico. So we had to go find these individuals. And like I said, this is the better part of 2 years. And I will say the bill is probably going to be upward of $35,000. So
So it
there's
sounds
another
like-
reason to write it down.
Sounds like having a will and having these things saves some money. And then, he mentioned the VSO. Are there resources for spouses that could bypass that cost or reduce that cost?
You mean the probate cost?
Or I guess really my question is that, what is the first step? So we go and we do all these things, we set it up, and the worst happens and something happens. Who do I call? Like, do I get a lawyer on board immediately? Do I go to the VSO? Because I wouldn't even know where to start.
So yeah, I didn't know where to start.
Yeah,
I mean,
like,
luckily,
this is all good
I say
information, but like, how do I?
yeah,
What is the
luckily
first
in
step?
luckily in my situation, I had a casualty officer, and the casualty when my husband passed was vast. I mean, we lost 30 Americans at one time. So it was a helicopter crash. And so it was a mess. So the entire command just stopped what they were doing. And so I had every single resource at my fingertips. Everybody was on speed dial. But I realized, like you're asking, people usually don't have that. That's usually not how it is. And so really, in that situation, when you're not in the absolute shock of what has happened, right? Whether it's incapacitation or it's a death, you should sit down beforehand and you should make sure that you've got a file. You've got a file with passwords, you've got a file with phone numbers, whether it be a person that you have a conversation with that say, look, if, David, my husband, something happens to him and I'm hysterical, there's a blue folder in the top drawer that's got all of our information. I want you to call my mom. I want you to call these 3 people. Here's the babysitter's information. Just have something to go to that someone who is of sound mind at that point in time has the ability to go to. So the first person to call, that's a really good question. So no one's going to know that your spouse has passed or the individual has passed until you have a death certificate and you start telling people, right? The bank's not going to know that your spouse is gone unless you call them and tell them. I would advise you, if I was an attorney, which I'm not, but in my situation, I wish someone who had told me just to not call them. I mean, we live in a day and age where there are lots of ways to access funds. So I can't tell you what ways those are, but we understand. With that said, I would say your life insurance policies, if you have those, you can call them, you can tell them, of that way you're getting that ball rolling and that those funds are coming towards you if you have a life insurance policy.
And then do you recommend that we can do this on our own? Because my thing is, if it costs so much to retain and, to just start this process, how much of it can we do on our own without accruing this huge bill? Because I mean, I think our family is like most Americans. We have the obligatory nest egg, but I'm thinking of our nest egg. We worked really hard to save. If something were to happen, oh my gosh, we need to save more. Like it would be depleted in a second,
Yeah.
it sounds like. So when do
So
we?
well, when I say this, and I mean this, it used to be in the state of Texas to where you did not have to retain attorney to go through probate. Now you do.
Yeah.
So you have to retain an attorney. So I would say, you know, the average American, you know, living the American dream, white picket fence, 2.5 kids and a dog, you know, you own a home, you have 2 cars, you know, things like that.
Kind of me.
Yeah. That's, you know, if you look at statistically from the census, that's really what, you know, the American dream is. You're looking at like a $3,500 bill to get through probate,
Okay.
especially if you have a will. If you both have wills and you guys are married, you're not a blended family, everything goes, and your children are from the same marriage, everything's going to go to you, even if you didn't have a will. But if you have a will and you do all that, I mean, we're talking $3,500. So when I said, you know, $35,000, that's when someone has died without a will. They've got, you know, the individual had, you know, 10 children who, under those children, they each had 5, half of them have died. They all have, you know, grandchildren. So finding that money accrues from finding individuals, drafting the documents, filing it with the court. So that's where the time, the attorney's time is what the fee, the cost is.
Do you know of any agencies that walk with spouses through this process, like any nonprofits or any service? I mean, that's got to be so overwhelming for someone. Like, there's got to be agencies out there that just like tell people kind of what we're hearing today. But I mean, I'm going to take notes, but what if you forget, or what if you're so overwhelmed?
Gosh, currently I don't know of a ton. I don't know of very many. I know that TAPS, TAPS, they're great. They have a lot of information on their website. To be completely honest, that form that Mr. Smith put up, that has some really good information on it with like Lorianne said, it is Texas specific, but that doesn't mean you can't dial that phone number and
for Texas.
Yep.
We're in North Dakota right now, but we're going back to home. So
exactly. So there's a way through those numbers, and that's a really good place to start, and to look at where you need to you know, what you can get, because, you know, active duty service members and veterans, there are different, you know, there's Social Security, there's VA benefits, there's also, you know, some things that come from DIC, which are different payments, dependence and indemnity, you know, payments. And so there are kind of different institutions that get paid, that pay out. And so that's a really good list to start at. And I'm so glad that he shared that, because
thank you very much.
Yeah, I got a binder that was like this thick, and you know, this like big thick thing, and I just looked at it. You know, I was 29. I had an 18-month-old baby. Like, I had no idea what was going on, and I didn't, like you say, I didn't know where to begin, and I certainly wasn't in the right mind. I mean that the first 3 years are a blur. I mean, just an absolute blur. And there's so much that comes along with this. And I do want you to know, you do not have to do probate a will immediately. You have time. You know, I would say get your bearings, wrap your brain around it. Of course, find out where you're going to get the financial support. But going through the court process, I mean, just take a deep breath, take care of yourself, and then cross that bridge. You know, 3 months, 6 months down the road, the code does not require you to do it immediately. I think it's 2 years. So you have time. 2 years. Yeah, you have time. So, you know, don't get overwhelmed by, oh my gosh, I just lost my spouse. Now I have to go through this court, you know, process, which is the last thing that anybody wants to do when you're dealing with such a tragic situation, whether it be that you lost them at a young age, or if you spent, 45 or 60 years with one another. There's no difference on the, the tragic scale. So don't think that you're, required by law to start this process immediately. That would be pretty, I would say, unsat for the court systems to do that, to require you to start it so quickly.
Awesome. Well, thank you so
Not a
much.
problem.
I've learned a lot, and I'm going to do a few things with my husband after this. I learned quite a bit. So thank you so much.
Of course, absolutely, absolutely. Happy to be here. Glad to be here. Glad to share the, the very short learning curve that I, got it all like fire hose at one point in time, but then was able to circle back around and really, go and study it. So, so I can give back.
Keri, thank you so much again for
Oh,
taking
thank
the
you for
time
having me.
to talk to us, and to our viewers that will watch this recording later. If you guys have questions, you can reach out to the Veteran Spouse Network, to me, Laurie Ann, the Transition Program Coordinator.